You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, you shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, Florida Supreme Court is now in session. Please be seated.
Good morning and welcome to the Florida Supreme Court. The sole case on our docket today is Garcia versus Adani.
Good morning. May it please the court, I'm Melinda Thornton, Assistant County Attorney. I represent Pedro Garcia, the Miami-Dade County Property Appraiser. Your Honors, at its start, this case only involved the single issue of whether the permanent residence of the Adonis minor children had been established in Florida so that the Adonis could get a homestead exemption on their property. The Third District allowed the exemption, but in doing so ignored that the burden of proving entitlement to exemption is placed on the taxpayer and that homestead exemption statutes are to be strictly construed.
So are we talking about a sufficiency of the evidence or a legal question? Because my understanding was that it was on cross motions for summary judgment at the circuit court level, and that the county, the property appraiser, never contended that there was more evidence that needed to be developed. So I'm a little confused about that, because that's really different than whether there's a constitutional issue involved.
Well, Your Honor, I think it's a little bit of both. In this particular case, at the oral argument at the Third District, that question was raised, and the taxpayer's attorney as well as the property appraiser both agreed there are no other facts in issue. Whatever facts there are contained in the affidavit. So there is sufficient evidence in the record to decide the case. That being said, we do believe the prime issue is whether the necessary showing of entitlement to the exemption, in other words, a sufficient showing that effectuated the intent of the parents in their affidavit, has been made.
But I don't understand that. If there is, I thought your position was that children of temporary or non-permanent aliens could never be entitled to this exemption. That as a matter of law, no matter what the parents said about their intention to have the children remain in that home, that couldn't be because their permanent home had to be in Honduras or something. That was the position of the property appraiser.
No, not exactly, Your Honor. It's a two-part position. The initial thrust was disagreeing with the trial court, who felt that citizenship was enough to establish permanent residence, and to emphasize that the Avalorum law, which is based on the common law, has at its premise the presumption that the domicile of a minor is that of his parents. But as we had argued in the brief, the second part of it is what's incorporated in Section 196.012 of the Florida statutes. And that says, once the presumption is established, in this case by law, at their birth as Honduras, the presumption is presumed to continue until a change has been shown. And at that point, what we discussed is that the affidavit of the parents doesn't sufficiently rebut the presumption. We're not saying
what would rebut it? So it's now your position, and has it always been your position that the presumption can be rebutted?
Yes, Your Honor, we've discussed.
And you've maintained that consistently throughout these proceedings.
Yes, Your Honor, as you'll see, it's discussed in the brief. First of all, you have the presumption that needs to be accepted, that you start with the domicile being that of the parent. Then the question is, was that presumption rebutted?
Okay, what would rebut the presumption? Your contention is that this affidavit is insufficient to rebut the presumption. What would be sufficient in the view of your client to rebut the presumption?
Your Honor, what the property appraiser would expect to see, and what we would suggest as a bright line test.
But what does the law require? I mean, what's your position about what the law requires? Not what you want, but what the law requires.
Well, what we're asking for is what we think the law requires, and that is that intent be effectuated by overt positive acts. Let's go back to the statute.
The affidavit says it is the residence of my wife and myself and the permanent residence of our 3 children. What more do you want than that?
Well, Your Honor, our position is that's a self-serving statement. How is that effectuated? In other words, have the Andonis come to the property appraiser?
What does he have to say for it not to be a self-serving statement?
It has to say, we recognize we cannot be here on a permanent basis. Therefore, here is an order of the court where we have asked the court to establish the permanent residence of our children in Florida.
So they've got, what you're saying is that they've got to go to court to get a court order.
I think I'm sorry.
Is that right?
I think that's the best bright line test. There may be other.
But okay. The fact that that would be a bright line doesn't necessarily mean that that's what the law requires or should require. Isn't it the case that parents regularly make arrangements for other people to take care of their minor children when they're going to be away from where the children live, and they don't go to court to have that formalized? That's going on all the time, where parents who have to be away for some reason entrust their children to responsible adults, and that's not a problem. But you're suggesting that in these circumstances there's got to be something more than that kind of ordinary arrangement. Now, let me ask you this. Am I
Yes,
I'm correct.
That is true, specifically because they're asking for a homestead exemption, which is premised on a showing of permanent residence, and because the 3rd District, in its opinion, said, and if you would let me quote the troublesome part of the opinion, the parents have adequately declared that whatever may become of their ability to remain in the United States in the future, they fully plan and intend for their U.S.-born children to permanently reside in the United States. How do they make that happen? Are they leaving the minor children in their home?
Well, don't you think that this is a yearly exemption? And so in 5 years, they're all in school, they were all born in this country, they're American citizens, I presume they go to school, and they've lived in that house since the condo was acquired. So in 5 years from now, if something happens and their parents have to go back to Honduras, they're either going to stay in that home with guardians, or they're going to leave. At that point, the homestead exemption is gone. So I don't understand this idea that the permanency means that someone has to establish from now until the age of majority. It's static. What we're looking at is a point of time for a 14-year-old, a 10-year-old, an 8-year-old, people that have been in this country and presumably are working since 2003, and we're talking about 1 year for an exam, right? The 2006 year. I don't know what's happened in 7, 8, 9, and 10, 11, 12, but nothing is res judicata or law of the case for each year that a homestead exemption is acquired. Am I correct or incorrect about that?
Your Honor, it doesn't have to be forever. On the other hand,
no, I'm asking you, could you litigate this if new facts came to light the year after? Can the property appraiser make a different determination, and then it goes to the Value Adjustment Board? They could make a different determination, and then if you disagree again, you go into circuit court, which, by the way, you bear the burden of proof in circuit court, correct? You, the property appraiser.
That is true.
Okay. So is it static, permanent decision that this is forever the permanent residence just because it was established in 2006?
Well, Your Honor, the basis of the property appraiser's requirement, they established it in 2006, is something that would carry over every year. And in Miami-Dade County, as may be in most counties in Florida, the homestead exemption, once granted, is automatically renewed on a yearly basis. Obviously, if facts change, then the analysis changes.
So that's what I'm saying. So if they end up where for the reasons of the visa, whatever, that they have to go back to Honduras. They're either going to take their children, at which point there will be no more homestead exemption, or they will have their children with either a guardianship that will be established or with relatives or whatever. And at that point, the situation will change, and the homestead exemption can be revoked if the facts, which is we intend for our children to live here in the United States, in Miami, in this condo, until their age of majority, that fact is changed.
Well, Your Honor, I think that might conflict, though, with the reasoning of this court in Guerrero, with the district courts in Descravan and Alcim, which all dealt with situations where you have people who are in Florida, working in Florida, have driver's licenses in Florida, have ties to Florida, but because they could not qualify as a matter of law as permanent residents, all of those factors did not matter.
But the children here are citizens of the United States.
But Your
Isn't
Honor,
that correct?
That is correct.
They
However,
can stay. They
Your
can
Honor,
stay in the United States.
If they were born here.
what it means, Your Honor, is that the parents, because they know that they are only here on a temporary basis, that means that they can go into court and make sure that if they leave, a temporary guardianship in the custody of family members or a standby guardian has been appointed so that they can effectuate
But they don't have
the
to
change.
do that. That's the question here. Do they have to do that under the law in order to establish that these children are permanent residents? Is that a requirement under the law to do that?
Well, the law doesn't specifically set out that procedure. However, in custody decisions, in guardianship decisions, that's usually recognized as the most
So if they
formal,
decide,
official way of establishing a domicile.
so if the parents decide that, or they find out today that they've got to leave in 10 days, and they have a relative here, an adult relative, that they leave their children with, that would not qualify.
Well, Your Honor, first of all, let's remember what the Andonis gave to the property appraiser. Nothing more than their affidavit.
I'm just asking you, however, that if they make arrangements, they have to go home. They have to go back to Honduras.
Right.
If they make arrangements with an adult to be here with their children in this condo, that's not going to be sufficient. Is that your position?
Well, first of all, it has to have been in place on the taxing day. Second, there are statutes. There's more than one statute in Florida law that recognizes that guardianships in those very circumstances can be established where you have a court order making sure that the schools, the hospitals, everyone knows that these minor children have a responsible adult who's been given authority to look out for their interests. It should be what Florida would
we have
require.
People all over the United States and in Florida who, for some reason or another, have to go somewhere or do something and leave their kids in care of another. I mean, I think I cannot imagine a situation of this family leaving their kids with, say, a grandmother or someone like that they trust, and we're going to make them go into court and somehow get a court to approve their family situation of leaving their kids with a trusted family member.
Your Honor, what we're asking for is a court or sufficient evidence otherwise, which we didn't have in this case, to establish that their permanent residence has been changed from Honduras to Florida. That's what we're looking for.
This is what I find absolutely incredible. 3 children that have never lived on a permanent basis in Honduras, 3 children that were born here. The property appraiser is saying their permanent residence is actually Honduras. That's your position. Is that correct?
That's the starting position, yes, it is,
Now,
Your Honor.
when they came in and asked for their homestead exemption, did the property appraiser said, we can't give this to you unless you have a court order showing that you have an alternative guardian that is a permanent resident of the United States? Was that told to this family?
They were told that they didn't qualify for
So
the
I'm asking you, did they say that the property appraiser's rules are that the only way that, because we can't figure it out on a case-by-case basis, is that we have a rule here that you need to have a guardianship? Was that ever told to them?
I personally don't know.
Okay,
I
and
doubt
there's nothing
in
on
those
the record
specific
about
words.
that. When is the first time that the argument is being made that the only way that the exemption can be granted is if the parents that are not permanent residents of the United States have a court order showing there would be an alternative guardian? When was that? Was that made in the trial court? Was that argument made in the trial court?
I don't believe that was specifically discussed in that way in the trial court.
Was it that made
Yes.
to the third district, but they rejected that but didn't discuss it in their opinion?
That's true. We did discuss, in fact, there were questions at the third district about does the affidavit as it was presented, does that sufficiently rebut the presumption of the domicile being in Honduras? The U.S. Supreme Court...
Now, by the way, where is the presumption? You said it was in a statute. It's not in the Constitution, correct?
It's not, because the Constitution doesn't define permanent residence.
Okay,
but
so it's not in the
places.
Constitution. Is it in a statute?
It's in two places, Your Honor. With respect to a minor child, the Department of Revenue has a regulation that's...
No, okay, well, that's not a statute. I'm asking you, it's in a statute.
What's in the statute, Your Honor, is 196.012, subsection 18. That says once a domicile has been established, it is presumed to continue until a change has been shown. And if you read that consistently with this court's decisions in Beekman and Chisholm and all the cases that recognize the common law presumption that the domicile of a minor child is that of its parents because that's your starting point, then the statute says that's presumed to continue until a change has been shown.
So what does that language in the constitutional provision, that language that talks about legally or naturally dependent upon the owner, what does that mean? Because it seems to me, if we follow your logic, then we have written that portion out of that constitutional provision.
I think what it means, Your Honor, is that permanent residence defines one or the other. Someone affiliated with that homestead has to be a permanent residence. We all know it's been agreed. The parents
are you saying
not.
the children can't be permanent residents?
Of course they can, but their permanent residence, which is presumed to be Honduras, has to be established
What
in
if the
Florida.
parents simply transfer the property to the children by quitclaim deed? Would they qualify then?
I don't believe that children can own the property, Your Honor. They're minors.
Children can't own property?
That's my understanding. But what we're saying in this situation is there are circumstances, obviously, that can be fashioned and should be fashioned to make sure that if these parents are told tomorrow they need to leave Florida, that their children can remain here as permanent residents.
So you're concerned about the children's welfare. Is that what the property appraiser is here to make sure that these children aren't abandoned in the country? I'm getting confused. I really am trying to understand the property appraiser's good faith argument here. So you're concerned about the children's welfare.
What we're concerned about is a parent coming in and saying, whether we stay, whether we go, we want our children to stay here. And we're saying, but that's fine, but you need to show, how is that going to happen?
It really seems to me, this is what you're saying is, and correct me if I'm wrong on this, but there's no particular statute anywhere that anyone can find that defines with any precision how you establish permanent residence. Is that a fair statement? For constitutional purposes. So we go back and look at common law concepts, and we look at one statute that doesn't necessarily implement here. Isn't that what you're trying to argue?
Well, and along with the regulation, which is based on Florida Supreme Court precedent, which acknowledges that presumption, you take it all together, and you have actually a logical framework. You start...
But there just is nothing right now that says that's the only way to do it.
And we're not...
Do you agree with that?
That's correct.
Okay.
And we're not saying that the only way is someone goes to court and gets a court order. We're saying that's the cleanest way. For instance, in the Department of Education case versus Harris, That's what the court
But
had
there's no
suggested
authority,
as...
on the other hand, that says if you do not do it that way, you do not qualify. Is that correct? There's no case authority.
There's no cases. That's why this is a case.
There's nothing. Well, that's what I said. There's nothing that says that if you do not do it this way, X way, that you cannot qualify for what the people have placed in our Constitution.
Your Honor, I think there's case law, though,
Could you just answer first and then explain it? I'm trying to understand. It seems to me there's no authority anywhere that says this is the only way you can do it for this constitutional provision.
that's correct, because the constitutional provision doesn't provide the definition there.
I understand.
But the cases in Florida, Snyder versus McLeod is one of them. All, when they talk about the common law presumptions of domicile, make it very clear that if you're going to establish a domicile somewhere, you have to do something more than just make a statement of intent.
Is domicile the functional equivalent of permanent residence?
Yes, in this context, and even the Third District recognized in its opinion that that's what we're talking about. We're not talking about citizenship. We're not talking about actual physical residence.
You have used all your time. I will nonetheless give you 2 minutes for rebuttal.
Thank you.
Good morning, and may it please the Court. Daniel Weiss Tanib Weiss on behalf of the parents David and Anna Andoni. Before the Court this morning is a constitutional provision, which bears some emphasis, and the issue before the Court this morning we submit is whether real property can qualify under Article 7, Section 6A of the Florida Constitution for property tax exemption for a homestead, where the parents are citizens of another country and the children are U.S. born, Florida born, citizens of the U.S., citizens of Florida, and therefore permanent residents residing on the subject property. Is citizenship, in your mind, the functional equivalent of permanent residence? It is, but we would submit that if you look at the statute, which is 196.012, subsection 17 and 18, you'll find that permanent residence is defined. So permanent residence can be citizenship. It doesn't not required to be citizenship, because if you're a permanent resident under immigration law, you would qualify. In this instance, it would be enough for the children to be Florida citizens, however you acquire that. But we're saying by virtue of the fact that they are U.S. citizens and Florida citizens, they definitely qualify.
Are we there was something in the Third District opinion, and since you obviously that interested me. They talk about the affidavit of your client, and then they say that there is no contrary evidence from which we conclude the affidavit was made other than in good faith. And then Judge Shepard went on to say, although one might wonder whether his assertions are congruent with the laws of nature we apply in this court, the constitutional laws of the state of Florida. What would you, I mean, you were not in his mind, but what did he, what is that, are we to make of that in the opinion?
I believe, and I infer, that Judge Shepard was concerned about children of 7 and 12 and 14 living on the property without having their parents present. But I think what we need to know is, and what we point out, is that this determination is made annually, and an annual application is required for homestead exemption. If there's any change in status, there's a reminder card that's sent out to each taxpayer who has a homestead exemption to inform the property appraiser.
So your opponent is incorrect when she says that once you establish homestead, it's automatic every year thereafter unless you do something affirmatively?
It doesn't continue automatically. It does continue automatically in the event nothing changes, and that's the function of the annual reminder.
But the property owner has an affirmative duty under the law to give the property appraiser notice of any relevant change in circumstances, and they can be in trouble if they don't comply with that. Isn't that correct?
In trouble, to say the least, because the property appraiser can go back 10 years and revoke the homestead exemption, and there's a 50% penalty per annum. They lose to Save Our Homes and 15% interest. And this is increasingly used as a revenue source in the counties throughout the state of Florida. So the answer to that is a resounding yes. It's not just a yes.
So is our concern, seemed like there was some issue about the welfare of the children, but what are we concerned about a non-resident, a non-citizen, fraudulently using their children to get a homestead exemption? In other words, what's underneath this constitutional issue?
There's nothing underneath it.
Well, is that the concern? But that's the concern, isn't it? Is that there is some potential for fraud. And what you are saying about it is that if something occurs and the parents have to leave this country, at that point, they have to notify the property appraiser of that change. And if they take their children with them, and there's evidence that they always intended to take their children with them, then the property appraiser can go back and do whatever it's going to do to that property, which obviously doesn't go back with them, stays in this country.
To be sure. What I would submit to the court is that underneath the constitutional issue is the Constitution. And the Constitution says that every person who has the legal or equitable title to real estate and maintains thereon the permanent residence of the owner or another legally or naturally dependent upon the owner shall be exempt from taxation thereon when established in the manner provided by law, which means to file a homestead exemption application. The application is a sworn application. It's before the court. It's in the record. It specified the specific basis that we're here on before the court, which we submit is not the sufficiency of the evidence. Moreover, going to Justice Perry's question, we submit that the children now happen to have attained the age of 18, 19, and 12. So even if there were a disability of non-age which attached to the ownership of property, that's no longer the case. So it's particularly important to recognize, as the court does, that tax assessments are done annually under Section 192.042, that the determination of homestead is an annual determination.
Well, what has happened, speaking of that, this was in 2006, correct? And so what's happened since then? Have they gotten the exemption or what?
Well, that's not in the record. But if the court wants a representation, they have got the exemption year after year. And 1 year,
And they've lived here?
Pardon me?
The parents have lived here?
The parents have lived here. They're still here. I expected them in the courtroom this morning. They're not here, but they're physically here.
I know it's not in the record.
It's not in the record. It's not in the record. And my response to that is the what-ifs. The property appraiser really, I think, is here on what-ifs. What if something happens in the future? And we say, what if the property is conveyed to the children? They can still be dependent on the parents because the second prong of
the business about the what ifs is it seems to me to be rather strange because people have homesteads in Florida who may have some prospect of moving out of Florida.
Of course.
Like everybody potentially has that prospect. And so the notion that someday something might happen that would cause them to move and not reside in Florida, I just to rely on that to establish ineligibility here seems to be quite bizarre. I'm sure you agree.
I have to agree with you.
I have a question about the Department of Revenue, and I see that the Solicitor General is represented here and read the brief, and usually the Solicitor General is comes in to defend a state statute. It looks like it's that they take the position, the Department of Revenue, that even though they have this rule, that rule is not a correct statement of the law. Now, is that your interpretation of their brief?
Well, my interpretation of their brief is that they say that the property appraiser has no constitutional or statutory authority to engraft onto the Constitution an additional requirement to import it from a statute which appears to have within it a vestige of a
former... You're talking there about the permanent residency.
I'm not. Frankly,
the residency of the owner.
Yes, who resides there on permission.
But I think that beyond that is the issue of this presumption. Is the law in Florida, should the law be that when you're talking about minor children who are dependent on their parents for their support, upbringing, etc., that there is a presumption that their permanent residence follows the permanent residence of their parents? Is that an appropriate common law presumption that should continue in this state? Or are you suggesting, and I haven't seen it here, that these cases from the early 1900s, a couple of them having to do with married women, are really vestiges of another time?
They're vestiges of a bygone era, but
they're really not as to children, because children do ordinarily, you would assume their residence is going to start out being the same permanent residence as their parents, unless there's something else that's shown. And so would your position be there shouldn't be a presumption, or it was rebutted by your affidavit?
I'd like to go directly to Your Honor's question. What I find fascinating about Your Honor's question is that it's predicated on a question of permanent residence rather than domicile. And while the county accurately and correctly stated that in this particular instance, permanent residence and domicile are indistinguishable, what we submit is that with respect to Your Honor's question, there arises a dichotomy between permanent residence and domicile. And I do not say let's do away with the presumption that the domicile of the children follows that of the father. It used to be the father, now we say the parents, because the parents, of course, are natural guardians of the children, both of the parents. What we say is that the presumption has been rebutted. We don't think we're here, by the way, on the sufficiency of the evidence issue. With all due respect to the court, we don't think the court is here about sufficiency of the evidence. We don't think that's what the role of the Supreme Court is in the state of Florida. And if that's what we're here on, we submit that jurisdiction may indeed have been improvidently granted. But
this seems to me, and please correct me if I'm wrong in looking at this.
Yes, sir.
This is far broader than foreign nationals and children. This deals with, this could be a resident of Ohio establishing someone in Florida as a dependent, living permanent residence of a legal dependent in Florida. The same piece of law would apply, correct?
Absolutely.
Yeah, so this is a broader general constitutional principle that we're looking at, and it just happens to be those are the facts of this case.
Yes.
But the principle is much broader than that.
It's broader. It's broader in the respect that, yes, if we look at the Department of Revenue regulation 12D-7.007, subsection 4, it contemplates a situation where a person may be a resident of another state, but why not another country? Now, interestingly, the testimony in the record, and there is some testimony, it's administrative tribunal testimony, and we submit that what the evidence is in the record is the affidavit of David Andoni. It's the affidavit of Angela Newman, who's a 30-year exemption director of the Department of Revenue, and we have sworn testimony of Ms. Angela Newman in a collateral proceeding involving the same kind of situation as we face here this morning. But what we submit is that we're here on uncontroverted facts, on 1 year, on a specific year, specific situation.
As to that 1 year and that specific situation, could you tell me what the record shows about the immigration status of your clients during that 1 year?
Yes, sir. As of January 1st, 2006, Mr. and Mrs. Andoni are both here as lawful residents. They are here residing, physically residing at least, in the state of Florida, in the municipality of Key Biscayne, in a condominium, together with their then 3 minor children.
When did their visa expire?
There's no indication it expired at all. There's nothing in the record to say it expired. That's a what if. What if it expires in the future?
So the record does not show the date of the termination of their visa?
No, nor is there any reason for it to. What the record does establish is, and I read from paragraph 8 of the affidavit, not of David Andoni, but of Angela Newman from the Department of Property Appraisal, and that's found in the record at page 24. The Andonis filed an application for Homestead Exemption for 2006, which, by the way, is attached helpfully to the affidavit of Angela Newman. It's a sworn application, as it must be. And helpfully, it's attached to the brief of the property appraiser. The following statement was included in the application. Ms. Newman says, quote, "My children are U.S. citizens, ages 7, 12, and 14, living at this address and are legally and naturally dependent upon my wife and me, thereby qualifying the property for homestead exemption." A copy of the homestead application is attached to the affidavit of Angela Newman as Exhibit C. Therefore, the facts are uncontroverted. The facts are limited to January 1st, 2006.
I want to go back to Justice Lewis's question.
Yes.
So you're saying as far as their legal status, that's not an issue here?
Correct.
Okay. The Constitution, I wasn't really familiar with the second position, is that you've got the homestead exemption if it's the permanent residence of the owner, which is the one we're mostly familiar with.
Yes.
Or another legally or naturally dependent person upon the owner. So that's clearly that doesn't depend on the permanent residence of the owner, or it wouldn't be an or. So I was trying to think of the hypotheticals or the real life situations where that occurs, such as, we take Ohio, somebody who has an elderly parent in Florida who is dependent on a son or a daughter in Ohio, and they buy a residence in Florida for their elderly parent who is legally or naturally dependent. Does that elderly parent then, does that property, is that entitled to a homestead exemption?
There would have to be a showing, and there has to be an adequate showing that the parent, if you will, is naturally or legally dependent. Now,
and how is that? I mean, I guess that's outside the record, but it seems that the actual fact of dependency will always create some question as to where the person is living someplace else.
Yes.
They buy this residence for their parent, or it could be, a divorce situation where, as a condition of the divorce, they buy the house. Say the mother or father can live in there with the child until their majority. That I was trying to think of how many situations are there where in the state of, and maybe we don't know this from the record, where this is always going to be a factual dispute, it seems to me, I guess, is that somebody is going to have to establish the dependency and why they're living in one place and the person who is dependent on them is living in that residence.
Yes, and that's essential, I think, to the recognition that what we're here on is an extremely limited issue, that it is a fact-intensive consideration. And, for example, we do know from the record that a federal income tax return was submitted by the Andonis to show that their children are actually dependent. Now, we think that the affidavit or the homestead exemption application, because it stated what Ms. Newman said it stated, as a sworn application, which is the form of the application, and which is another protection. But additional protections are found in the regulations of the Department of Revenue under 12D-7, which is the homestead exemption regulations, which say that the owner, the applicant for homestead exemption, has to show to the satisfaction of the property appraiser, one, that there's no other homestead exemption that attaches to that family in the state of Florida, and two, that there is indeed a natural or legal dependence that's predominant or exclusive.
And here, here we don't have, because it's a minor child, we don't have any issue of, they're not contesting dependency. They're just questioning the permanent residence.
Yes. And parents are the natural guardians of the child. They could make some other arrangement in the future, as the court has discussed with the parties this morning. That's not the case January 1st, 2006. The record is uncontroverted. It's not disputed. If anything, it's reemphasized by the affidavit of Angela Newman and by her testimony with regard to the circumstances under which there might be a college student who might be over the the age of 18, or the age of 18, or over the age of 18, living on property where the property owner lives elsewhere, and by elsewhere I mean either not on the subject property but elsewhere in the same county, in which case still only one homestead exemption is appropriate for that family unit. May live elsewhere in Florida, does not claim a homestead exemption elsewhere. And by the way, there's a lot of cross-referencing by computer now to make sure that there are not two homestead exemptions claimed in the state of Florida. It might be an owner who lives in another state, and so on.
Can I go back to something I just saw in the affidavit of Newman?
Yes.
And this goes to Justice Kennedy's question. It says that Mr. Andoni's visa was issued on May 25th, 2000 and expired on May 25th, 2005. Now that doesn't seem to be an issue, but you've been referring to this affidavit. That's a non-issue you're saying, but it is in the record that it says it expired.
I guess I would have to stand corrected because that's not controverted. We haven't controverted that. But what does controvert that, we submit, is the Constitution of the state of Florida, which says that every person who has the legal or equitable title to real estate and maintains thereon the permanent resident of the owner. Not the case here. We don't contend it's the case. We never contended it's the case. There was an affirmative representation in the homestead exemption application that that's not the case, or the permanent residence of another legally or naturally dependent upon the owner shall be exempt from taxation. Now, what we submit is we would allude to what Justice Overton said many moons ago. Well, it's the 1980s. It's not many moons ago for some of us, where this court, not this court, the members of the court, but this court, the Supreme Court of Florida, dismissed as improvidently granted jurisdiction with regard to the Lisboa case, which was also a non-permanent resident parent case, which came out of the 3rd District and out of Miami-Dade County. And Justice Overton cautioned against excessive involvement in the immigration laws of the state. And we think at some point we don't want to have the property appraiser of the county, elected official though he may be, and although we address him as the honorable and we give respect to the office, we don't think that they're properly, those are equipped statutorily, constitutionally, or otherwise to be deciding immigration law. So if there's some issue, I don't know whether the Andonis renewed their homestead exemption status at some point. The property appraiser did not raise this with regard to the denial of the homestead exemption. We never
You mean their immigration status?
Yes, sir. The immigration.
You mean renewed their visa?
Pardon me?
You mean renewed their visa?
The issue of the renewal of the visa. We raised the issue of the status of the parents by affirmatively stating they're not permanent residents, and they're not permanent residents. Whether their visa was renewed by January 1st.
Nobody's contending that the property appraiser is not contending that the legality of their presence is an issue here.
Well, then, if that's a non-issue, we would move on and we would simply state.
I don't know. I mean, we're here. We're not here to decide the immigration status of someone 6 years ago. Just that you had said that they were here legally, and you referred to this affidavit, and the affidavit says that the visa expired. So I'm just, it's not you seem to be dancing around it. It may not be an issue that we will examine, but it's certainly on the face of the record. We don't have something that shows that this is incorrect. The subparagraph 5 of the affidavit of the property.
You do not. But what I'm saying is constitutionally that doesn't matter. If it were still the case here.
But you answered questions to Justice Kennedy that said their visa had been renewed or hadn't been expired. That's all I'm referring to.
I didn't use those terms, but I did say there were lawful residents as of January 1st. And this certainly addresses that issue, and I'm concerned about that factually. And if anything, I recede from that because I have no. I don't recede from that. January 1st, 2006 is not May 25th, 2005. And if the property appraiser, for the purpose of the trial court proceedings, cross motions for summary judgment, went to the immigration authorities and found out that this was issued on May 2000 and expired on May 25th, 2005. I don't see anything here that says that it wasn't renewed. So,
let me ask you this question. I mean,
yes, sir.
That as I read the constitutional provision,
yes, sir.
in isolation,
yes, sir.
There's nothing that prohibits even an illegal entrant to own property, is there? Is there a prohibition?
Yes, that's correct.
There is a prohibition.
We're not here about that.
Right. I mean, that seems to me is that's not what our issue is.
No. That's a concern for immigration. But we are here in 2012, and frankly, I expected Mr. Andoni to be here with Kristen, now 12, the other children being 18 and 19 years old. And that's not a non-issue here, but we're not here on that issue. But the question is, if the owner were a quote illegal immigrant, would that be an in good faith claim? So that's an issue for another day. We submit. Thank you. We would ask the court to affirm the 3rd District.
Thank you.
Thank you.
I'll give you 4 additional minutes since counsel got 4 additional minutes.
Thank you, Your Honor. I just want to correct a couple of factual matters. Justice Quinch, you asked what happened in subsequent years. The Value Adjustment Board granted the exemptions, not the property appraiser. The property appraiser has been consistent in its position because there hasn't ever been anything more than the affidavits saying it's our intent that the children be permanent residents. Also, we want to be clear, this is not an immigration case. This would apply to anyone from out of state. The analysis that we believe common law of domicile is incorporated in the ad valorem tax dictates that the focus be those presumptions and whether they were rebutted, and that would be true whether someone was from Alabama or Ohio or from a different country.
But in terms of the constitutional provision that anticipates that there will be circumstances where the permanent residence of the owner is separate from the permanent residence of an individual legally or naturally dependent upon the owner. And the situation that is most common would be children legally or naturally dependent upon their parents, but it could be elderly parents. The property appraiser's experience in this would show that, and would you agree, that those become factually unique issues in each situation?
That's correct, which emphasizes even more the importance that the property appraiser not be expected to grant or deny homestead exemptions just upon self-serving statements. In your
but
scenarios,
your value adjustment board really is the one that disagreed with the property appraiser, and then the law allows you to go into court, the property appraiser, and establish why the value adjustment board was wrong.
Right.
And that's what I think why we have this presumption mixed up just in the status of this proceeding, because the value adjustment board presumably felt the affidavit was enough to rebut, and now you come forth in the circuit court with contrary evidence, and there isn't any.
Well, no, not with contrary evidence, but just with saying that as a matter of law, a mere statement of intent is not enough. And the different factual scenarios
but
that
it
could
wasn't
come up.
Really, because we are here on a broader principle, but also the facts of this case and whether there's a justice or injustice. There's nothing that shows that, again, there was any kind of sort of fraud or manipulation of this homestead exemption. These are people that came, this E-2 visa from somebody that's going to be putting capital into this country. Their children were born here. They were being raised here, 8 and 12 and 14. They lived in this house. They were taxpayers. I just don't see where the problem is that the property appraiser has not, thinking that somehow that the constitutional intent is being frustrated by providing this exemption.
Your Honor, it's because the Constitution requires permanent residence, and we look to what this court itself has stated in looking at permanent residence. It's a matter of law
But the question
not,
here is what is adequate to overcome the presumption, right?
That's correct. When
I mean,
you're
that's what
dealing
this
with
all and you decided that something more than this declaration by the parents was necessary to overcome the presumption.
That's correct. And let me give you a perfect example why. You noted in the record that when they made their application, they presented an expired visa. Now, by the time in Miami-Dade, the Value Adjustment Board hearings can be a year and a half afterwards. That wasn't an issue by the time they got to the Value Adjustment Board hearing, and since we had denied it anyway, that wasn't the focal point of the case. But it shows the problems that can come up with the various factual scenarios. And when someone cannot themselves, as a matter of law, as the owner, say, we're permanent residents and they need to rely on the permanent residence of their dependents, there needs to be some factual basis that the property appraiser can rely on to make sure everything's in order.
But that second portion of the constitutional provision about the naturally dependent, does that turn on whether or not the parent's visa was in effect at that time? I don't get really the connection you're making between whether or not their visa had expired.
There's no connection at all, because whether their visa was expired or whether their visa was temporary, they're still not, as a matter of law, permanent residents. So their children need to be established as permanent residents, and the presumption needs to be overcome. And what we're saying is the self-serving affidavit wasn't enough to do that.
You could have an adult child totally disabled. How about, disabled child? And what are you going to have? I'm going to have got my canceled checks. I pay everything for this individual. And so I'm missing out. I mean, if we're going to require legal proceedings for all these things, why would it not be better done somewhere else other than just making it up as we go along?
Well, two answers, Your Honor. First of all, if the parent was not going to be with that child and that child was going to be left without the parent, you would normally have a guardianship in that situation so that decisions could be made. And second, because we're talking about a homestead exemption, which is not a matter of right, it's a matter of entitlement, strict construction under the laws of the state of Florida, and for that reason we would request that this court reverse the decision of the 3rd District and give the property appraisers the clarity they need to be able to implement the laws consistently.
We thank you. We thank you both for your argument. And that concludes today's session of court. The court is adjourned.
All right.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.